What you know, Alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It is after midnight on February 28th. Hope you guys had a great Thursday. I was just crazy busy with life. I didn't really get to sit down and start watching this hearing until about 7 o'clock last night. So this is going to be part one. Part two will be out around lunchtime, maybe a little bit later tomorrow. If you guys have followed this case, you know Charlie and Donna seemingly talked nonstop from the time he was arrested up until she was arrested. They didn't see each other again until the day her trial was supposed to begin. Charlie did not waive that conflict of interest issue with his former attorney, Dan Rashbaum, representing Donna at her trial. That delayed her trial for months. Donna was very upset that day, but she's got new defense attorneys and it seems like they have settled in. I'm going to link the calls that were played at the hearing in the description so that way you can go listen to them if you want. Also, Harvey Adelson was in attendance. The defense was up first and they are arguing the motion to suppress the jail calls. They called investigator Jason Newlin with the state attorney's office in Tallahassee to the stand. The Leon County Jail uses Securus, and these tablets that are a lot like our phones, you can do FaceTimes, voice calls, send and receive emails, text messages, videograms, photos, and audio calls. But you have to have money on your account to be able to do this. And clearly, Charlie had plenty because there were a lot of calls made. They talk about the fact that jail calls are recorded. The inmate and the person receiving the call are told the call will be recorded and subject to being monitored, and you can hang up if you don't want to be on a recorded call. The inmate has a PIN number to enter when making the call. And this ensures that the calls that are made by the inmate are tracked. The call will terminate when both parties hang up. Donna did not hang up. We got that hot mic call where in the background she is heard talking about, among other things, going to a country that does not extradite. And that led to her being arrested at the Miami International Airport. The witness did an extraction for a specific time period with Securus, which generated a report, and he also received portions of these calls recently for this hearing. When the calls were being played, I noticed Donna is just kind of breathing in and out very heavily. She closes her eyes a few times, and you just see a physical reaction to her hearing these calls. This was after Charlie's conviction. He's in solitary confinement and on self-harm watch after the verdict. Charlie tells Donna he can't look outside into the pod like he could in the cell he was in before he was found guilty and moved. He said there is a one-way mirror that staff can see in, but he can't see out, and it makes him a little claustrophobic. Charlie said he's waiting for the chief to come see him, and Donna asks if Dan Rashbaum can get the chief there sooner. And Charlie says no. He tells Donna he has a mattress on a plastic box to sleep on. He says Mr. Rashbaum was talking about ways Charlie could potentially get an appeal. Maybe a few months down the road, a juror writes something stupid on a blog. And he says the harder the judge rules, the better chance you have for an appellate issue. Charlie does acknowledge the judge did rule in their favor, gave them the benefit of the doubt at times. And essentially, Charlie knows it's going to be a long shot for him to get an appeal. Donna asked what Mr. Rashbaum thinks, and Charlie said Mr. Rashbaum told him essentially the same thing. The judge ruled in our favor several times, and there was really nothing improper that was done. Donna tells Charlie there's a lot of things they have to do, and they have a very tight time frame. Things to do with Charlie's son, Steinberg, and her friend Susan and Susan's husband, Rick, are there to work with them because they have a couple of hours of stuff to work on to take care of Charlie's son. Susan, by the way, is an attorney that was helping Donna with estate planning. Donna tells Charlie it's a lot. You're going to be okay. You'll get out of that stupid room and then you're going to feel better. And when she has something to tell Charlie, she will call Mr. Rashbaum and then let Charlie know when to call him. And at this point, the call drops. The defense has the witness say that Charlie was disconnected. Charlie tries to call Donna back 6 times after this dropped call. The witness is asked if Charlie was unsuccessful because his PIN number was already in use, and the witness doesn't know. They play another call from November 8th at 6:38 a.m. They start this call 57 minutes and 13 seconds into the call. Donna is crying. She says they had the best attorney who did lots of research, stayed on the phone the first few months after Charlie was arrested and he was in solitary confinement. Donna says that her and Harvey will look at each other and wonder if there's something else they could have done. And she talks about having the best jury consultants. You hear some beeping, and Donna says, Charlie, can you hear me? She tells somebody in the background that it clicked off because the call lasted for an hour, but he will call me back. One thing that always stood out to me about this phone call is how on the phone with Charlie, she's crying and very upset, but immediately stops crying and talks normally about things she needs to do. You hear Donna say, they're not recording my call. And then she says, if they are, and this is when her end disconnects. Charlie tried to call back at 7:38 a.m., 7:40, 7:44, 7:45, 7:52, and 7:54. The defense tells the witness that this call was to Donna's cell phone and asks if when the call drops, could it be tower issues, battery issues, or the caller hung up, and asks if that's termination of the call. The witness says for one of the parties at least. On cross, prosecutor Dugan, she points out when a call is made from the Leon County Jail, both parties are alerted the call is being recorded before that person can accept the call. The witness agrees and says it lets the person know that they need to hang up if they do not want their call to be recorded. The witness said there are thousands of calls between Charlie and Donna since Charlie was arrested. The prosecutor asks on that hot mic call where Donna talks about fleeing to a non-extradition country, if Donna had properly hung up the phone, would the recording have stopped and would we not be able to hear anything else she said? And of course, the witness says yes. The judge asks the witness if he's aware of any prior calls that were not hung up, and the witness doesn't know. On redirect, the defense says you're not aware of any other similar situations happening in the thousands of phone calls, and the witness says not that I've listened to. They ask if he could possibly pull a report to see if it had happened previously, and he said he could. During the call we played earlier, Donna realizes Charlie is not on the phone anymore. Is there any discussion about the phrase non-extradition? The witness said he would have to listen to the whole call, but he knows there was talk about getting out of the country. The defense says this is probably more relevant for the bond motion, but does Donna say she's not coming back? The witness said that Donna did say we will have to tell Wendy we're leaving the country, and there was no indication about coming back. The prosecution moves over to the motion for bond, and they call Mike Hayden, registered nurse. He is a health services administrator at the Leon County Detention Facility. At the jail, they are equipped for basic life-saving measures, wound care, chronic care medications, and things like that. Prosecution points out that there are people with very serious medical conditions who live at the Leon County Jail, such as cancer, and the witness agrees. He's asked what medical staff they have there. They have dentists, dental assistants, licensed practical nurses, certified nursing assistants, registered nurses, mental health professionals, psychiatrists, nurse practitioners, and a medical doctor. There is a nurse on site 24/7. Doctors can prescribe medications and also refer an inmate outside the jail for treatment. They're Monday through Friday, normal business hours, but there's always a doctor on call. He explains if an inmate is having a heart attack or a stroke, they will call EMS, but they can also do CPR and try to stabilize the patient until EMS arrives. Anyone can say an inmate needs to go to the hospital, even if a doctor is not on site. The defense asks if there are any kind of call buttons for people to press if they are having a medical event. And the witness said that on the medical unit, they do have those call buttons like you would have in a hospital. If someone has a non emergency request, they can fill out a medical form, and those are handed out during MedPass. The nurses will review those requests, and if they think the inmate needs to see someone, they will facilitate that. If the nurse decides the inmate needs to see a doctor, they typically will be seen within a day or two. And the prosecution asks, so if the request is made, are inmates typically seen quicker than if they were not in custody? And the witness says yes. As far as elective procedures, those would be evaluated based on medical necessity. And if deemed a necessity, they would get the inmate seen outside of the jail. He says if Donna needs to be taken to the hospital or seen by a specialist, they would facilitate that. She has been evaluated for the conditions listed in her motion for bond. The prosecutor asks if medical staff has observed any hearing loss with Donna, and they have not. He's asked, is there a medical necessity for earwax removal? The witness says no, but if it were deemed a medical necessity, they would facilitate that. Just a side note, Donna says she has really, really small ear canals and she needs to have earwax removal done professionally several times a year. After Donna complained of shortness of breath, was a chest x-ray done? The witness says yes, and her lungs were normal and clear. They did order albuterol for her back in 2023, and recently she complained her shortness of breath has gotten worse. So she was put on a scheduled breathing treatment for around 5 days. As far as pain in her left shoulder, medical staff noticed a limited range of motion in her physical exam, so an x-ray was done to look for fractures or dislocation. It showed nothing. She was given some exercises that she could do to help with her pain and her range of motion. He's asked if Donna reported mild pain to the medical provider on February 3rd. The witness says yes, and if she needed further treatment, she would have received it. At this point, the defense objects and says the prosecution gave them a stack of Donna's medical records from the jail last week, and they asked what lawful process was used to get the records, but never got a response. Before the hearing started, they asked the state if they were going to introduce the medical records, and the state said no. It's clear they've had discussions with the witness about Donna's medical records. The defense never got an issuance of a subpoena so that they could object. No search warrant, and Donna certainly didn't sign a waiver, so it appears they've unlawfully obtained Donna's medical records, and they asked the witness's testimony be stricken from the record and no further testimony allowed. The prosecutor said they were not aware that the defense didn't get a response from Mr. Newlin about how these records were obtained, and says she can ask what a subpoena issuance entailed to get those records. She reviewed the records this week, and obviously the witness did too. The prosecutor said she's not moving these records into evidence, and if they are moved into evidence, it would be all of her records. She just wants to ask the witness about them as far as things that are relevant to Donna's motion for bond. The judge asked the witness to step down for a moment so they can determine how the records were obtained as part of the motion for bond. And the judge says this does go to the sufficiency of Donna's medical care. If the witness has knowledge of the care given, he can testify to that as any other record. If there's a lawful objection, he's like, let's hear it. The prosecutor said they would like to ask the witness some questions that don't pertain to the medical records. So the witness gets back on the stand and they talk about the jail practicing evidence-based medicine. That's peer reviews, looking at clinical studies, trial and error resources, research. And he explains some inmates don't have the knowledge or the education about their own personal health, such as never being diagnosed with a mental health disorder, or somebody may have cancer and just didn't know they had it. The prosecutor asks if some inmates fake it to go stay in a hospital or a treatment center as opposed to being in custody. The witness says yes, and they do it for sympathy as well. He's asked if the jail prescribes narcotics, and he said, not usually. It's a currency, it's highly abused, and it can cause safety issues. Donna gets over-the-counter pain relievers. The judge asks the prosecution if they plan to go further into the previous testimony of Donna's physical ailments. No. The defense is up. Did you talk to the state about Donna's medical conditions? And the witness says, yes, right here. He reviewed the medical records given to him by the state attorney's office. She asks about those medical alert buttons, and the witness says they're in the medical unit, but not in regular cells. The defense wants to know about the medical forms requesting care. The witness said that their custody staff and nurses carry those with them. The defense asks if he's aware Donna asked for care on February 1st due to a cut she got from a washing machine, and a nurse was in the unit. So Donna requested a form to ask for a Band-Aid, and there were none. The witness isn't aware whether or not a Band-Aid was available, but he does know that Donna was requested to be seen and was seen. The judge interrupts and tells the defense that they just objected to the state referencing records that you appear to be cross-examining him on. And she says, I thought you were asking me to cross-examine the witness. The judge says he did, but if she's going to examine the witness concerning the medical records, they'll be available to the state as far as all the topics that are raised. So the defense says they won't cross until they find out how the state got the records, because that's what cross is all about. The witness steps down, and investigator Newlin gets back up. He says he sent a subpoena to the medical oversight for the detention facility. It was last week. He was asked to draft a subpoena for this hearing. He explains Prosecutor Kappelman was asking questions to a Mr. Toomey, who is the representative for Yes Care. Mr. Toomey said he needed a subpoena. The witness did that and sent the subpoena back to Mr. Toomey. When asked how long it took to get those records back, the witness said he doesn't know if they have them yet. The prosecution asked if they had those, would a copy have been sent to the defense by Prosecutor Kappelman's assistant? The witness says yes, that is standard, that they would put that in discovery and provide it to the defense. The defense is up and asks if, before obtaining Donna's records, did you give any notice to the defense that you were seeking her medical records? And he says no. Were you instructed to do that by anyone in the state attorney's office? No. Is this the practice that you obtain medical records without giving notice to the defense? And the witness says no. His understanding was Mr. Toomey asked for a subpoena and said, I would bring the records to the hearing, but that's all he knows. The judge rules that the witness can testify to any knowledge he has based on his independent review of those records as jail staff providing care, and he can also testify to the same regarding Donna's records. If the defense keeps objecting, they can handle that as a separate matter, and any questions by the defense regarding information from the records on cross will be fair game to the state on redirect. The defense is back up and asks questions about the jail's standard for care, like x-rays for shortness of breath. Do you do steroid spine injections in the jail, or do you refer that out? Obviously, they refer that out to a specialist. They send people out for referrals for non-emergent situations almost daily. The defense asks about not doing a procedure on Donna's ear to get the wax out. Is it because they don't provide that currently? The witness said they just got this request in. When she raised the issue, they had never heard any history of that, and there was nothing in the records about it. She was assessed by a provider. The provider saw nothing. If there is an actual need, they can accommodate and coordinate Donna's care. On redirect, requests to the ears were February of this year? Yes. Did the doctor notice hearing loss? No, not based on the assessment. They move on to the shortness of breath. Every time she's been seen for her respiratory system, it appeared clear. She had no issues taking in air, and her pulse ox levels were around 98. The witness says that's correct and points out normal is 96 to 100. The prosecutor says, and when she got cut, she got Neosporin and a Band-Aid. The witness says yes, and they checked her a week later for signs of infection, and there were none. Donna was also educated to report any signs of infection or worsening symptoms. Donna did get a tetanus shot. We are back to the suppression motion, and the defense calls Donna Adelson to the stand. They did help her up to the stand, and I can't say nothing about that, y'all, because I would have face planted if I tried to go up any stairs with those shackles. They talk about the call from November 7th of 2023 that was about 3 o'clock in the afternoon. Donna says she was in her living room in the apartment. Harvey was there, as well as her friend Susan and Susan's husband, Richard. She said Susan is her attorney who does estate planning and was there to provide legal counsel. When asked about Charlie and where he was, Donna gets a little emotional and said it was after his conviction and he was in his cell. She knew the call dropped when she asked Charlie if he could hear her, and he didn't respond. She said call drops were frequent, and she says it happens a lot, unfortunately. In the past, she would hang up. November 8th, 2023, that 6:30 a.m. call. They asked about the dropped call. She believed the calls were over, and she went on about her business. Regarding the November 7th call, did you agree for your attorney-client conversation to be recorded or the conversation with your husband? And she said, no, of course not. When asked if she hung up when she realized the call was over, she said, I thought I did. And there was nothing further from the defense, but on cross. Harvey, your friend Susan, and her husband were in the room during the call. Susan's husband was not your attorney? Donna says no. You were informed you were being recorded, and if you didn't want to be recorded, you could hang up. Donna says, I accepted the recorded call. She's asked if she typically hangs up her calls, and she said, I think I do. But the prosecution says, this call, evidently, you didn't properly hang up, and Donna says, evidently. Have you ever forgotten to press the button? And Donna says it may have happened. Have you ever pocket dialed people when you were out of custody? Donna looks a little confused about the lingo there, and the prosecution explains it's an accidental call you didn't mean to make, and Donna says it's possible. On redirect, the defense asked Donna the consent to record the call. When did that end? She says when Charlie hung up. When the call was over with, it was over. She steps down for now. And we get into the arguments. The judge says, under the precedent established by Smiley versus State, in order to exclude what are complained of wiretapped interceptions, there's a need to show there is a subjective expectation of privacy in their statements, and the exception is one that society would accept as reasonable. As to the subjective expectation, showing the defendant has met that burden, it now shifts to the state as to whether that one is reasonable. The state says the caller consents to recording before accepting the call. If you don't want to be recorded, you can hang up. The state did not intend for her conversation in her home with her husband and friends to be recorded. The fact that she was recorded wasn't caused by the state. It was caused by Donna. The defendant says there is a reasonable expectation of privacy, but that starts once the call is hung up, and she's responsible for hanging up. They use the analogy, if somebody says something incriminating within earshot of law enforcement, thinking law enforcement can't hear them, but they can, that's on the speaker. If they did not walk away to have a conversation, it's their carelessness. And they cite the Florida statute 93403. The defense says the good faith exception doesn't apply because the call was in violation of that statute. But when you look at every subsection of that statute, it applies to intentional intercepts. The prosecutor says they've provided several cases to the court to consider, and there's nothing directly on point here of this situation having happened just like this in the past, but there are different cases that deal with accidental recordings. She cites cases where defendants were heard by law enforcement after a phone was accidentally left off the hook, but there was a court-authorized wiretap in place. It was authorized under the plain view exception. That's an exception to the Fourth Amendment's warrant requirement that allows an officer to seize evidence and contraband that are found in plain view during a lawful observation. It was a legally recorded line where they can be recorded. And just like in our case, though the defendant in that case failed to properly hang up, and that allowed law enforcement to hear the conversation in the room due to the inadvertent nature of the recording. In Otero versus State, a child accidentally activated an answering machine at a home she was staying at. It recorded the conversation of the mother and the child, unbeknownst to either of them. The Third District Court of Appeals found the admission of that tape did not violate the statutory exclusionary rule found in 334 because 334 prohibits intentional interception of wire communications. The taping in that case was not intentional, just like our case. They cite a few other cases, one where an unintentional recorded resulted from a butt dial that was allowed in, and the court held that a person who knowingly operates a device that is capable of inadvertently exposing his conversation to third-party listeners and fails to take simple precautions to prevent such exposure does not have a reasonable expectation of privacy with respect to statements that are exposed to an outsider by the inadvertent operation of that device. The defendant here failed to take simple precautions of properly hanging up when she knew it's a recorded call, and the state asked the defense motion be denied. The defense gets up to argue their case and says the right to privacy is enshrined in the Florida Constitution. Article 1, Section 23 of the Florida Constitution provides the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure, against the unreasonable interception of private communications by any means shall not be violated. The Florida Constitution also provides every person has a right to be left alone and free of governmental intrusion into the person's private life. The Fourth Amendment provides similar protections. 934.02 defines an oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation. He cites a case where someone was in an interview room at the police station and called a co-conspirator. The recording equipment in the interview room was powerful enough, it picked up the other end of the call. Based on what law enforcement heard from that call, they obtained a search warrant for the caller's cell phone and found images that are illegal, as well as other evidence of a crime the two had been engaged in. Another important factor is the person on the other end of the line knew that the other man was at the police station waiting to speak to law enforcement. The courts held the other person had a subjective expectation of privacy, and his expectation was one society accepts as reasonable. The defense says one distinguishable factor he needs to acknowledge is that the person on the other line did not know the caller was sitting in a police interview room, to where Donna knew Charlie was in jail and had consented to that call with Charlie and knew it was being recorded. The issue is the conversation Donna had after Charlie's end dropped, and she believed the call was no longer being recorded. The November 7th conversation is with her attorney and her husband, who are both confidential relationships. The judge asks, doesn't the warning about the recording almost directly speak to that issue? He says he will read the case where the call was accidentally recorded at the police station, but points out that person was not warned, you are being recorded. The defense says he'll get to that, but Donna believes she ended the call on her end. He doesn't think it's reasonable to require an individual in a situation like that. Oh, I just had a recorded call. Let me repeatedly hit the end button. You hit it once, that should be enough. Donna believed she ended the call. The last case also addressed something that's important. Chapter 934.03 is a general intent statute. It doesn't require the state intentionally record after one party drops off. Wasn't the system designed to intentionally record? The answer has to be yes. The investigator testified yes, it's designed to intentionally record. Now, I don't know if the judge was tired or interested, but he kind of gives a So I'd like to know what that means. The state anticipated they would argue accident or inadvertent, but this is not an accident. An accident is something that doesn't happen frequently. Donna testified Charlie would drop off of calls frequently. The system is intentionally designed to continue recording. And under Chapter 934, I submit when either side is no longer on the call, the system has to stop recording, and any additional recording is a violation. That's what we have here. It's not an accident. Securus Technology system is designed to continue recording after one party drops the call. Investigator Newlin testified it terminates when both parties hang up. I submit that's not what happened. It continues to record. It's not reasonable, and society is not expecting someone sit there and continue to hit the end button to make sure the call stops on their end. The judge asked, do you have to continue to hit the end button, or do you hit it once and it's disconnected? The defense says Donna testified she believed she hung up. And so the judge says, go ahead. The defense says because this is not a specific intent statute, is the system designed to record? Yes. There's no evidence this was accidental or inadvertent. It's not a pocket dial, as the state argued. We know Charlie intentionally called his mom, and the system recorded the call. There is a reasonable expectation that society would accept this call as anything other than something that's entitled to the protection of 934 and the Florida Constitution. At this point, they take the break, but the state comes back and says they want to put one more thing on the record for the suppression motion. At the end of the November 7th call that the defense moved into evidence, at the end of that call, the last thing you hear is Harvey Adelson say something along the lines of, what's this? A call that didn't end? The implication is he must have picked up the phone and saw the call didn't end. And that's important to note, because had Donna looked at her phone, she would have seen the same thing. That's all. The defense wanted to respond again and said the system is designed to record after the inmate disconnects, and the system knew Charlie tried calling back, as testified to by investigator Newlin. The judge said he will review the cases submitted by both parties before he makes a ruling. That's it for now, but on part 2, we're going to break down the Arthur and bond motion, and Donna is back on the stand for a good portion of that second half of the hearing. We will see you soon.